My presentation is on pregnancy, discrimination, and family and medical leave. It's Chapter 12, Employment Law, Neil Clement's presentation by Terry Eunice. These are the checklists that we're going to go over throughout the presentation. Learn the requirements for taking family and medical leave. Define serious health conditions. Understand that an employee's health benefits are maintained during family and medical leave. Appreciate the employers may require a health care provider certification of a serious health condition. Know that the medical leave may be granted on a intermittent or consecutive. And the checklist continues as you realize that the family leave applies to the fathers as well for mothers for the birth of a child. Be aware that adoptive parents are entitled to leave for family leave. Understand the purpose of the Pregnancy Discrimination Act. Be apprised of why some employers do not want to employ pregnant workers. Be cognizant of existence of a fetal protection policies. Family and medical leave. The FMLA permits an employee in any 12-month period to take up to 12 weeks of unpaid leave for a birth of a child, adoption of a child, for the care of a spouse, child, or parent who has a serious health condition or because of a serious health condition that makes the employee unable to work. To be eligible, the employee must have worked for the employer for at least a year and must earn 1,250 hours for service during the previous year. Family and medical leave, it continued. In case of a birth adoption, the employer is required to provide the employer with at least 30 days notice of his and her intent to request family leave. When a serious health condition is foreseeable, the employer must provide 30 days notice to take into consideration the employer when scheduling treatment, if this is practicable. Serious health condition. It is defined as a situation in which an individual is in a hospital, hospice, or nursing home, or requires continuous medical treatment in one of the following ways: incapacity for at least 3 days or 2 or more visits to a health care provider within 30 days or 1 visit within 7 days. Pregnancy or prenatal care. Permanent illness from long-term conditions like cancer or stroke. A chronic condition such as diabetes or respiratory distress. Multiple treatments required for illness such as arthritis or kidney dialysis. Medical certification. This may be required by an employer. The health care provider must provide the date when the condition began and its likely duration and a medical explanation of the Defense Authorization of Act of 2009, Military Caregivers Leave. The Defense Authorization Act of 2009 entitles a spouse, a parent, a child up to 26 weeks of unpaid leave to care for a military service member from their family who has sustained a serious injury or illness while serving in the armed forces. Qualifying exigency leave, whatever. Yes, I'm sorry. This provision in the Defense Authorization Act of 2009 extended the FMLA 12 weeks unpaid leave to family members who must attend to children, financial and legal arrangements, and needs to the service member while on leave. Airtime Flight Crew Medical Family and Medical Leave Act of 2009. The FMLA provides coverage for those who work approximately 60% of full-time schedule over the course of a year. The full-time schedule has to be 40-hour work week. This has ruled out flight attendants and crew members because they do not work a full 40-hour week. Their schedule is by the airline flights. The Air Flight Crew FMLA remedies this and permits flight attendants and their crew members to full advantage of the family and medical leave. Paid leave. In 2004, approved partial leave, paid leave for 6 of the 12 weeks of family medical leave for employees of private employers. In 2010, partial paid leave became effective in these states of Washington and New Jersey. The reason paid leave is advocated is that many workers who are covered under the FMLA cannot take unpaid family leave. Maintenance of health benefits. When an employee takes family and medical leave, he or she is entitled to maintenance of health benefits while on leave. If the employee doesn't return, he or she may be charged by the employer for the health care premiums paid while on leave, unless the failure to return is due to condition of serious health condition. Pension, life insurance, and other employment benefits may be suspended during the period of the leave. They can be restored immediately upon the return of the employer. Pregnancy discrimination. This occurs when an employer must make a tangible employment action because of a woman's pregnancy. Pregnant women must be treated as the same as other applicants or employees. They must be judged by their ability to perform rather than on their physical condition. Pregnancy disability must be viewed differently from any other disability. In 1978, a discrimination on basis of pregnancy became illegal in the United States with the passage of the Pregnancy Discrimination Act and an amendment to the Title, 11 of the 164 Civil Acts right. Some employers have instituted prenatal counseling programs to give medical and emotional assistance. These programs reduce absenteeism, minimize complications during the pregnancy, and can otherwise help a woman work longer and more productively during her pregnancy. Fetal protection policies. They are put in place by companies that research, manufacture, warehouse, transport, and use hazardous chemicals and toxic waste. These employers are concerned by a liability standpoint about these effects these chemicals may have on their workers, particularly female workers in their childbearing years. Summaries is from the Employment Law Book, New Challenges in the Business Environment, the 6th editions. My clip art came from the Microsoft PowerPoint. Thank you.